Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Hello and welcome to the session on whistleblowing, transnational whistleblowing. I'd like to thank you all for attending and thank the conference for this wonderful invitation and the ability to share some insights with you. Whistleblowers are proven to be the single most important source for detecting and providing usable evidence on frauds, money laundering, bribery, and other white-collar crimes that are hidden from public view. Today's session, we're looking at two specific developments in the law. One, recent decisions of the U.S. Securities and Exchange Commission, which is the agency that governs our Foreign Corrupt Practices Act whistleblower program, and developments in Europe for a directive on whistleblowing. By looking at these two developments, we can get a good understanding of where whistleblowing stands and why it is so essential. We're going to begin with the SEC's recent rulemaking. This was a 2-year process. President Trump appointed the current 5 commissioners of the SEC. 3 are from the Republican Party, 2 are from the Democratic Party. And there was a big issue. Is international whistleblowing bipartisan? Will a Republican administration stand behind whistleblowers as the Obama administration had when the Dodd-Frank Act was passed? 2 years of negotiation, meetings, letters. And at the end, the single most important takeaway is that every commissioner of the SEC strongly backed whistleblowers and the program. So we're going to look at some of the comments first by the chairman of the SEC, appointed by President Trump, and what he said. So the first quote is, they're looking over a 10-year period of time. And the analysis is that the whistleblowers are a critical component to detect wrongdoing, especially where frauds are hidden. So this is the official position of the SEC, bipartisan. The chairman went on and talked about what has happened over the last 10 years within the SEC program. And I just want to repeat, the SEC program manages the Foreign Corrupt Practices Act cases. So the SEC is sitting on the most important transnational anti-corruption law. So the way they're viewing it and the progress that is occurring impacts all whistleblowing worldwide. This is the big law. There are other transnational laws, but this is the one everyone looks to first. So let's see what happened over the past 10 years. The SEC collected, this is all again from the chairman, $2.5 billion collected in remedies directly related to whistleblowers. Now this $2.5 billion number is totally understated, because it's taking the SEC a number of years to adjudicate cases. Sometimes it could be like 6 or 7 years They do an investigation, they have to get the sanction, they have to then adjudicate whether the whistleblower is entitled. This is what's already happened. I can tell you from the cases that I'm personally aware of and what's happening out there, this is the tip of the iceberg. That 2.5 billion is probably more like 20 billion collected, but this is what's been adjudicated. Then it goes down. 1.4 billion in disgorgement, and a lot of disgorgement penalties come from Foreign Corrupt Practices Act, and 750 million returned to the investors. Harmed small investors. This represents the success of whistleblowing, and this is why the program received full bipartisan support. It's completely working. And again, the chairman continues. Numbers never tell the whole story. Listen to this, a clear and loud voice of our commitment to implement a robust and effective whistleblower program. This is a message to all transnational whistleblowers, to all international persons who may be working with whistleblowers or cultivating whistleblowers. This program, there's an intent to make it robust and effective. And they want to say that in a clear and loud voice. And I can't underestimate this because there's so much skepticism about whistleblowing. Will the government really pay? Will they keep confidentiality? Will they protect their sources? And what the chairman is saying here in a bipartisan way, in a loud and clear voice, the answer is yes. I will also say we have filed many cases before the SEC. We have won large awards. We have many cases pending. And I can tell you right now that the staff that administers this program is highly professional and, from my perspective, in my experience, have never done anything to compromise a whistleblower. In short, the program can be trusted. And here, continuing with Mr. Clayton's analysis, he's now expressing appreciation to the whistleblowers. And he explains what we know as whistleblower advocates to be true. Our whistleblower program has been a success because of their efforts, the efforts of the whistleblowers. Listen to this. Working together, we have stopped frauds and prevented losses for countless investors. The key word here is working together. This is what we have seen. We have seen the whistleblower partnering with the Justice Department and the SEC, working together. And that's a very different than a lot of the stereotypes of whistleblowing. Some of the dramatic cases like Mr. Snowden or the Ukraine whistleblower here in the United States, where there's tremendous press attention to this conflict, where President Trump or others may have been hostile to a whistleblower. That all happened, and it can't be denied. This happens. Whistleblowers can be very controversial. They can be very political. But we put that aside when we're looking at this war against corruption. And transnational whistleblowing specifically, whistleblowers from foreign countries that are using our laws, yet are at tremendous risk if their identities are ever revealed. Working together. And I can tell you it is successful. So now let's look and go to transnational whistleblowing specifically. The countries in red are countries in which a whistleblower has gone and filed with the SEC on corruption. These are almost all Foreign Corrupt Practices Act cases, although the scope of the U.S. laws are extremely broad. They cover not only all U.S. companies, persons, and subsidiaries, they cover companies that do transactions in the United States, such as send emails or banking transfers through the United States. But even more significantly, they cover publicly traded companies on the Paris Stock Exchange, the London Stock Exchange, the Moscow Stock Exchange, Johannesburg Stock Exchange, any international exchange. If those companies permit Americans to buy their stock through a process known as an ADR, an American Depository Receipt. It's a technical process, but the scope of these laws are extremely broad. And again, as I mentioned, there are others similar to the Foreign Corrupt Practices Act, especially through the IRS and others. So you can see that international whistleblowers are using the law, and they're able to file in the United States confidentially and anonymously. This is a breakdown of the countries. 129 separate countries whistleblowers have come from, and the SEC alone has received 4,538 cases from these countries. It's simply miraculous. Especially, I don't even know how these people learned about the law. You know, how did someone in Rwanda or Senegal or Nigeria or Nicaragua, how do they learn that this even is a process? How do they even know how to file? It's quite interesting, but it's working. And one of the reasons it's working, and we'll get into it when we talk about the EU directive, is there's really not much of an alternative. This is the best show around. It works. And this is just a summary of how many people have come in internationally. I just want to again reiterate, and we're going to go through some of the now actual decisions and statements of the SEC about the eligibility of foreign nationals. So what is so important about this is, first, let's hear what Kevin O'Daniel had to say. Again, one of the executives who runs the enforcement program for international. It makes no difference whether the claimant was a foreign national. Okay, the whistleblower seeking a monetary reward can be a foreigner. The claimant resides overseas, never came to America, lives in Russia, lives in France. The information was submitted from overseas. Great. So the French whistleblower files the information in the United States, generally through a U.S. attorney who files it on their behalf. And the misconduct comprising the violation occurred entirely overseas. So in a bribery case, you can have a company that's traded on the Paris stock market, but selling their stocks to Americans. You can have the person paying the bribe, say being French, the person accepting the bribe being South African, the bribe being paid in Johannesburg, and guess what? We have U.S. jurisdiction. This is the head of the whistleblower office essentially repeating the same words. Whistleblowers, whether they are located in the U.S. or abroad, provide the valuable services to stop wrongdoing. This is the former chair of the SEC praising the program. So you can see it's very bipartisan. Chairman Clayton, appointed by Trump, former Chairman White, appointed by Obama, they're saying the same thing. The SEC whistleblower program is working. Before we jump to the new rules that were passed, I just want to mention the Commodity Futures Trading Commission. This again is another statement from the Commodity Futures Trading Commission. But read what they are saying. The award is significant. That means the payment they are giving to a non-US person is significant because it signals to whistleblowers around the world that anyone with information about potential violation of the commodity laws can participate in the whistleblower program. And what does that mean? The right to be anonymous, full confidentiality. You can partner with the government in investigating the case. And most significantly, you can get an award of between 10 to 30% of the sanction. The Foreign Corrupt Practices Act, although primarily administered by the SEC and the DOJ, I just want to touch on something about the Foreign Corrupt Practices Act and the Commodities Exchange Commission. If a company pays bribes to get access to commodities or to move commodities through ports, that may impact the worldwide commodities market in pricing. Because say they can, the price of the commodity in the markets may be impacted because of the payment of the bribes. So the Commodity Futures Trading Commission is looking for foreign bribery cases. And again, if you think about the worldwide commodities markets, and you don't need to be attached to a publicly traded company, you can begin to see that this Commodity Exchange Act is a big deal. And this is just briefly what I've said, that the whistleblowers under both the Securities and the Commodity Exchange Act can file anonymously. Eligibility does not depend on U.S. citizenship. You get an automatic award of between 10 to 30% if your information leads to a successful action. And since 2011, these two agencies have paid whistleblowers over $800 million in awards. But I will tell you now, as just the tip, it's going to be much larger. As I mentioned in the beginning of the presentation, the SEC has made new rules for its whistleblower program. These rules were subject to a debate of over 2 years. In the beginning, the proposal was not good. I do believe the commissioners and many on staff didn't fully understand the importance of whistleblowers. A new administration, new people coming on board. But over the 2-year period, the commission opened up its doors. We were able to meet with 4 of the 5 commissioners personally, the chairman, his chief of staff. We submitted numerous letters. Other people could meet. It was a very open process. And they listened and they learned, and the enforcement staff of the SEC provided data about how valuable this program is. And after 2 years, a consensus was reached. Everyone didn't agree on everything, but everybody agreed that the program was important, needed to be protected, encouraged, and enhanced. But there was one rule change that any potential whistleblower or lawyer for a whistleblower or advocate in any way must fully understand. They tightened the rule on applying for eligibility for an award. Their justification was appropriate. They're getting thousands and thousands of requests. So unless people use a standard form and come into the program in a very specific manner, it could be a bureaucratic nightmare for them. So they're requiring everyone to file this form known as a Form TCR. It's available on their website. It's fairly straightforward. But if you do not use this form, you can lose your right to collect an award. So even if the SEC uses your information, even if you are the hero, you may get nothing if you don't use this form. And that's one of the reasons why advocates like myself, it's very important that we now go out and make sure that everyone knows. A letter to the chairman of the commission outlining a fraud might result in you being disqualified. A phone call to someone in enforcement might result in you being disqualified. It's slightly counterintuitive. The way the rule works is as follows. To be eligible for an award, you must initially file your whistleblower claim on the Form TCR. So your best bet is just file it on the Form TCR and then make your phone calls and send your letters. If you do not, you have 30 days from any contact with the SEC to file the form. So let me explain that a little more. I get on the phone to the chairman of the SEC. I lay out a major fraud. I now have 30 days to file the TCR form. If I don't file it, I can lose my case completely. So you file it and you have 30 days to fix it. Now there's an exception. If you don't know you're supposed to file this form, you also get 30 days from what's known as constructive notice. And that also can include talking to an attorney about getting an award. That attorney is presumed to know that they should tell you to file the claim. So if a whistleblower contacts a lawyer and says, hey, I wrote a letter to the chairman of the SEC setting forth a major fraud. And that lawyer says, great, wonderful. Let's see if they do a sanction and you'll get your money. Guess what? The answer is no. If you hire a lawyer to represent you, you have 30 days to file that TCR if you've already contacted the SEC. This requirement to file the TCR concerns when you first contact the SEC, or, as I said, this 30-day grace period, or a grace period if you didn't know what your rights were, etc., etc. On the TCR form, they ask you, have you spoken to anyone from the SEC? Now, you have to fill out this form accurately and truthfully. So you have to check the box and say yes. And you have to say who from the SEC you spoke with. And believe me, in my experience, a majority of whistleblowers have made some type of contact with the SEC. And then often they're told, hey, file a whistleblower claim or do something. But once you fill out that form and you state you contacted the SEC and here's the person I spoke to, that is the information the SEC can use to determine whether you're eligible. If you're filing that form a year later, you missed your 30-day deadline. They will also know who you spoke to from the SEC. That's the issue of constructive notice. They can call up that person, that SEC investigator, and ask them, hey, did you tell this whistleblower to file a Form TCR? And if that investigator says yes, and a year went by, guess what? You're no longer qualified. The government could collect $1 billion and you'd be eligible to a minimum $100 million award. But because you didn't file the form, you get nothing. It's very important for everyone to know. Now, their rationale for tightening this is justifiable. In other words, I don't know if this rule could be challenged in court. I'm not saying it could or couldn't. It might be able to be because it's very harsh. There are exceptions. They do have some discretion, but it's fairly harsh. We argued that if the commission knows that you were the source, they should give you the award regardless of the TCR. The commission did not go that far. They still require the TCR, but they give you avenues to correct, to amend, to file. Now, on the other hand, a TCR is completely to your advantage. This is not something you want to run away from. This is something you actually want to use for two reasons. First, your TCR information will go into a centralized computer system. So if there are people in the SEC, it's a very large organization, that are working on a case that might impact the information you have, then they know you exist and can contact you. Because unless the SEC uses your information, you can't get an award. So it's to your advantage to try to get your information to the people at the commission who may actually do the investigation or who are already doing the investigation. So that's the first reason. The second is if you want to be anonymous. If you want to be anonymous, you must fill out the form. And what happens is, this is how it works. You fill out the form. You give it to a licensed U.S. attorney. That licensed U.S. attorney blacks out your name and identifying information. Also, any information that you're providing, that lawyer can delete, or not so much delete, but can say, this information will reveal the identity of the whistleblower. You can't directly use it. If there's an email with the whistleblower's name, you can tell the commission you can't show that to the company. It will expose the identity of the whistleblower. Or you can just black it out yourself and tell the whistleblower, and tell the commission and put the warning on it. And the reason why the anonymous form must be filed by a licensed U.S. attorney is because that attorney has to sign the form, and that attorney is under an ethical obligation to make sure the claim is being filed in good faith with evidence behind it. It's the way the SEC can police anonymous filings. It's a good thing. So a TCR is not bad. You just have to know to file it. That's the main rule of the main takeaway of what just happened. Just to give you an idea of what a Foreign and what's going on in Foreign Corrupt Practices Act today, these are just some of the recoveries. Now remember what I said. the whistleblower is entitled to between 10 to 30% of any recovery. So if you look at this German company, I don't even know how to pronounce it, medical, they got $231 million in a sanction. That means if there was a whistleblower, that whistleblower must get an award of $23 million minimum and could get as high as $70 million. Or if you look at the one that went for $965 million, if there's a whistleblower in that case, they must get a minimum of $96.5 million. And yes, the SEC recently paid its first $100 million award. This is mandatory. If your information results in the sanction, you must get 10%. You can get as high as 30%. That's a big deal. You don't want to miss out. These are some cases that came in recently under the Commodities Exchange Act, and you can see the amount of sanctions. It works the same way. If it's a $12 million sanction, that whistleblower must get at least $1.2 million and could get as high as, $4 million. Bank of Nova Scotia, that whistleblower, if there was a whistleblower, must get, $12 million and could get $36 million. I mean, these are not small amounts. These are the actual awards paid by the SEC and the Commodities Futures Trading Commission to international whistleblowers that the government has admitted to paying. So the award decisions are very confidential. The government releases very little information about them. They don't say who the whistleblower is. They don't say, sometimes they don't give direct amounts. They don't say who the company was. Why? It's a very confidential program. They don't want companies to figure out from the decisions whether there even was a whistleblower in the case. But you can see this is what's out there. So you got one whistleblower got 30 million, another got 27 million, someone else gets 900,000. This is all in relationship to the how big the case was. But you can see they're paying. This is a big deal. Now, this really says it all. This is how much money has been paid to whistleblowers under the 4 main whistleblower laws. Commodity Futures Trading Commission has paid, in the last 8 years, that's when they started the program up, $120 million in awards. Mark my word, that amount is going to get much, much larger. There's big cases that are awaiting. SEC is paid $720 million. And again, that will be larger. The IRS, between 2012 and 19, they have a program that covers tax frauds, tax underpayments, illegal offshore accounts, money laundering, any matter that's investigated by the IRS Criminal Division. They've already paid $861 million to whistleblowers, including $100 million, $104 million to one tax whistleblower, Bradley Birkenfeld. Now, the Department of Justice false claims, and again, this law also has transnational application. It goes to people who sell goods to the government, who get contracts, Medicare, Medicaid, drug companies, whether they're national or international. We did a major case against a Japanese manufacturer. There's a lot of international cases under false claims. It's the oldest of the laws. As you can see, the numbers here go back to 1987. It's kind of the mother of all the laws. This is the first one that came out, and because it works so well, they passed the others. But you can see they have paid, as of 2019, $7.397 billion to whistleblowers. I put up these numbers to make a point. The programs work. The government does pay. Consequently, if you have information about frauds and corruption or bribery, don't leave the money on the table. It is now, in many cases, far more profitable to turn in a corrupt act than to participate in one. I also want to say, and I've mentioned this in prior presentations, that there's no Boy Scout criteria. Yeah, if you're good and honest and a great person, they'll give you an award. But you can also be a participant in the frauds. The US government and Congress and everyone knows that often the best source of information is someone who is participating in it. When the False Claims Act, the original version, was passed at the time of the US Civil War, the leading Senate sponsor said it takes a thief to catch a thief. They understood that they want to get people from within the conspiracy to turn in their co-conspirators. If you're the kingpin, if you planned and initiated it, you can't profit from that. And I don't believe that's happened. But if you're a participant in it, you clearly can get an award, even if you sign a paper with the government admitting to your own crimes. This is very important for everyone to understand. The payment of these awards alters the equation. And once you can be anonymous and confidential, it makes it very possible to be a successful whistleblower under these laws. The OECD, many of you know that, a major international organization working on bribery and international corruption. They came in and did a site visit to the United States to determine how our foreign bribery program is working. I participated in one of those site visits, praising the program, obviously, but they talked to everybody. It was very detailed. And all of the judges in this site visit were non-US. These are people from other countries coming in to see how we are doing. And here is how they describe our Foreign Corrupt Practices Act program. So I'm saying this because when I tell you that the SEC and the DOJ are working with whistleblowers, paying awards, cooperating, when the OECD came into the United States to audit our program, they agreed. Here's their finding. The working group congratulates the United States for its sustained and outstanding commitment to enforcing foreign bribery. Enforcement has increased remarkably. We know why. But this is what they're saying about us. This is also what they said. The Dodd-Frank Act's multifaceted protections constitute a good practice, given that they provide powerful incentives for qualified whistleblowers to report foreign bribery. So, before we go to the EU directive, I just want to summarize. The United States has a number of very effective whistleblower reward laws. They all have transnational application. They all promise some level of confidentiality or anonymity. The career investigators and agents who work these programs are committed and are professional. And it's a real big mistake that if you have information about any type of crimes, that may be covered under these laws, that you do not contact an attorney and find out whether you or your client may be eligible for a very large award. Be a big mistake. So we're going to put that aside. So as many of you know, the European Union passed what's known as their EU Whistleblower Directive. This directive sets forth specific criteria for a minimum whistleblower law in every country of the EU. So it's guidance to say that to be consistent with the directive and your obligations as a member of the European Union, you have to do a series and offer a series of protections to whistleblowers, but you can offer more. You can make it a better law. So the directive is essentially a minimum floor that they could get all the nations in the EU to agree to. So that's telling you that it's not the best. The directive is more of an outline, and it is my professional opinion that if nations just implement the minimum required, they will be completely ineffective laws. And the reason is they have no incentive to get whistleblowers to report corruption. The minimum floor is strictly defensive. You get caught as a whistleblower, you have some rights. But if you get caught as a whistleblower, you're in trouble. And we know that. You can lose your job, lose your career. You might have to be forced into years of expensive litigation. The amount of damages you get may be very small. And because in almost every whistleblower case, it's one whistleblower against a big company or a government agency, it's stacked against the whistleblower. So yes, having a minimum anti-retaliation law is a good thing. And the EU directive is a good thing. What's really important here is the way each nation implements the directive. So as you see here, all European Union countries have to implement a whistleblower law by the end of 2021. And as I said, the directive sets forth a framework. But this is, and I like to say this, a generational opportunity to ensure that EU nations have effective whistleblower laws. So every parliament is going to have to debate this and vote out a whistleblower law. So there's a tremendous opportunity for anyone supporting whistleblowers, parliamentarians, special interest groups, public interest groups, lawyers, whistleblowers, to get off their duff and push for effective laws in Europe. So my law firm is engaging in this effort. We have united with a number of European NGOs and the National Whistleblower Center. It's a US organization, but we're pushing to try to push every member state to implement effective laws. This is a tremendous opportunity. So what needs to be done? These are three areas that we analyzed in the directive that need to be enhanced or fixed or covered in some way. First, the directive has no reward-based laws. So a nation can still set up something like our Foreign Corrupt Practices Act or our Commodities program or another reward-based program. They can do it. The directive doesn't require it, but they can do it. Given the success of the U.S. program, given the OECD's stamp of approval, we think it's imperative that every nation start looking at their whistleblower laws and to see if there should be rewards on some of the issues, especially for tax evasion and money laundering. Okay, that will make it a really good law and incentivize people. The directive also has a very bad part of it, Article 22. In Article 22, people that whistleblowers file cases against, including corporations, can file lawsuits against the whistleblower. Now, this is a disaster. Why would anyone in their right mind become a whistleblower if the big banks and the big corporations can sue you and destroy you? So the way it's written in Article 22 is very vague. They don't prohibit it, and they do permit it. So what it comes down to is how each member state implements Article 22. They have to put strict limits on counterclaims and libel lawsuits. We have those in the United States. There's lots of examples. There's lots of precedents. Anyone who has ever promoted a good whistleblower law has understood that you can't have whistleblowers being sued by the people they're turning in. So this is something that there should be a tremendous effort on, and to ensure that every nation state, as they implement this, puts strict limits on potential counterclaims. The third part, which I found quite interesting, is that the directive says that if a whistleblower wins their case, they're supposed to get relief. But they don't say what they should get. No way. The laws have to be very, very clear. They have to explicitly spell out the damages a whistleblower can get, and they have to make sure that those damages that they can collect will actually make that whistleblower whole or restore that whistleblower to the position they were in before they ever blew the whistle, or even more. So as the nations debate it, they have to make sure you get back pay, front pay, benefits, reinstatement, compensatory damages. They have to pay the attorney's fees. They should seriously consider punitive damages. Without significant damages, the directive is a total failure. So again, that's up to each nation state to make sure that if a whistleblower wins an EU whistleblower directive case, they can be made whole. So that's what's going on in the EU whistleblower world. As I say, we are part of a campaign. Anyone can reach out to me. We're looking for more support in Europe to try to get this right. It's a generational opportunity. By December of 2021, every nation's going to pass their whistleblower law, and they're not going to want to hear from us again for a long time. This is it. This is the chance to make things right. For more information and on this PowerPoint, I will ask to be made fully available to every participant in the conference. We will also put it on my law firm's webpage, which is at kkc.com, and most likely we'll further publish it. But either way, here are two sources of information. that will really help explain where the directive is. The first is a 4-part series that I wrote with a colleague of mine, Mariah Best, at the law office, in 4 parts article clearly explaining what has to happen to the directive to make it good. And then the second one is a memo we are circulating to all the EU states with a cover letter that's coming from the 2 European NGOs, the Whistleblower Center and my firm, setting forth how they should implement the directive, putting formal comments on the record. These documents will really help you. You can endorse them, push them forward. These are the reward laws of the United States, all of which have transnational application. You can do research into them. If you're interested in, if you think you have a case and you're interested in pursuing it, you can contact me and my firm. The contact information is here. I have written a book known as the New Whistleblowers Handbook. It goes over all of the laws that we just discussed and explains how to use it. This is the handbook. In the past, when these conferences have been live, I have made the handbook available free of charge to people who thought they could use it. Because we're doing this remotely, I'm still going to make the handbook available. So if you are attending the conference, you can just write in. You'll only be asked to pay shipping and handling. We will make it complimentary to anyone who attends this conference for payment of shipping and handling only. I have found that the handbook is a really good resource once you've heard this. And the principal reason we're doing this is to spread the word and really bring in whistleblowers in this fight against corruption. So thank you all very much. Here's more contact information for my firm, and have a great afternoon. Thank you again for attending the conference. It's been my pleasure.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.